Good evening, everyone. Before we start, I'll kindly ask the participants to write in the chat box their full name, role, and team code. Thank you.
Hi, good evening.
Good evening, everyone. Respected judges, dear participants, on behalf of the organizing committee, I extend a very warm welcome to you all to this final round session of the fourth virtual International Client Counseling Competition 2026. At the outset, may I kindly seek the permission of our learned judges to begin the proceedings for this session?
Please.
Yes, thank you.
Thank you, respected judges. Respected judges, it is an honor to have you preside over this final round. We sincerely thank you for your time, expertise, and continued support to this competition. To the participants, heartiest congratulations on qualifying to the final round. Your advancement to this stage reflects consistent performance and strong client counseling skills. We wish you all the very best for this round. The fourth virtual International Client Counseling Competition 2026 is aimed at fostering practical advocacy skills with a focus on client interviewing, counseling, legal strategy, and preventive law, which form an essential part of professional legal practice. This edition of the competition is hosted by International University of Sarajevo with GD Goenka University as the academic partner. We gratefully acknowledge their valuable collaboration and support. We are privileged to have with us industry experts as expert assessors for the final round of fourth virtual International Client Counseling Competition 2026. Mr. Sukumar Patajoshi, Senior Advocate, Supreme Court of India, and Ms. Kritika Agrawal, Advocate on Record, Supreme Court of India. We are beyond honored to have you all with us. A brief reminder of the final round format. Allotted time is total of 60 minutes, comprising 45 minutes client consultation period, 10 minutes post-consultation discussion, and up to 5 minutes question from the judges at their discretion. For smooth conduct of the round, time reminders will be announced in the Zoom chat as follows: 20 minutes left, 15 minutes left, 10 minutes left, 5 minutes left, 2 minutes left, and finally, time over. Participants are requested to strictly adhere to these time announcements. With that, I now invite the participants to begin their client counseling session. All the very best to both the counsel and the client.
Good afternoon and welcome to this client counseling session. I will be the lead counsel for this meeting, and we as a firm specialize in commercial law matters, and I believe that's why you have inquired with us today. At this juncture, I'd like to welcome my co-counsel to introduce herself.
Hello, I will be one of the co-counsels for this interview.
To lay some groundwork, I would like to mention to the clients that this interview is specifically for the purpose of us gathering information about your situation and how we can best proceed with the next steps and advise you with solutions that are adequate for your interests. During this interview, we will be at some points asking probing questions, but this is just for the purpose of us gathering information and understanding your situation and how we can best help you. Additionally, if you see us taking notes, we will make sure to keep eye contact with at least one of you so that you will know that you are always being listened to and heard throughout this entire interview, as that is our priority as well. If you have any other questions, please do let us know. I will pass it back to my co-counsel now.
Thank you very much for that. As my co-counsel has stated, we are here in an advisory capacity and we are here to cater to your interests, cater to your express interest that you will divulge during this session. We will be practicing proper time management, turn taking, and confidentiality will be practiced during the course of this meeting. Anything that you divulge during the course of this meeting will not be expressed to any external or third parties. Furthermore, the Zoom link is encrypted, therefore no third parties or external parties can access this Zoom link. The confidentiality that does exist between us as your lawyers and you as our clients will be further buttressed and protected by an NDA agreement, which I do have. And with the permission of the host, I would like to screen share. It appears that screen sharing has been disabled. Therefore, I will attach it to the chat and it will be forwarded to the respective clients, executed on our end, and it can be sent back to us once you have executed it. And with that, I'd also like to welcome the clients to introduce themselves for familiarity purposes and start this session off the right foot.
Thank you so much, co-lead counsel. My name is Simran Devi. Simran works just fine, and I will be the representative for Titan Security Limited today.
Myself, John Silva. I am a representative of Orion Global Capitals.
Lovely. And with that, I would like to proceed with asking the first.
Counsel, can both of the counsel mention their names to us?
Yes, my name is Sania.
My name is Rasha.
Lovely. And
Thank you, counsel.
you're welcome. May I proceed with asking the first question, if that's all right with the clients?
That's
Yes,
absolutely
it's okay.
fine.
Lovely. So if I could please ask both clients to give their background in terms of their situation and why it's come to this. We have received the papers, but could you just go into a little bit more details into why you've come to see us and some extra details so that we could provide some context in order to streamline the process and be able to guide you best?
Yes, that's absolutely fine. And I think Mr. John Silva, with your permission, I'd like to go first. As I'd mentioned earlier, thank you. As I'd mentioned earlier, I am the majority stakeholder representative for Titan Security Limited. And to just lay out ground facts, John and I know each other because we are actually here for the same reason. So, three companies: Orion, which is a Dubai based company, Titans, the company I'm representing, and Quantum Algo got into a tripartite agreement. Now, this agreement was for the sole purpose of ensuring executing a high frequency trading, and this was to be done in three different stock markets. So the New York Stock Exchange, the London Stock Exchange, and the Singapore Stock Exchange, respectively. The reason this was to happen was to ensure that we're able to make use of our niches. So Orion, and I know Mr. John Silva is a better place to talk about this, is a private equity firm. I come from Titan, and Titan is a brokerage uh, business, and it offers brokerage services. And then Quantum Algo offers algorithmic trading. So the idea was to utilize all these three skills and all these three components of our companies to ensure that we're able to do successful trade market stocks and exchange and all that. So with your permission, I'd like to show you something to put a bit of things into context. So please do let me know if you can see what I am sharing. So this is the contract. I've added a bit of color to make sure that we're engaged as we progress, but I can share the same on email. I believe we had an email chain going on. So as you can see, this was um, executed January 15th this year. But before we get into looking at that, let me break this contract down in a simple way. So as I said earlier, it's a tripartite contract between Orion, Titan, and Quantum Algo, and that was for stock exchange. The financial value was $800 million. And so you can see that we have a lot of money going on. These three companies had really poured themselves into ensuring that this venture was a success. Now we're going to look at the technical obligations, and with that, I'm going to the actual contract, and I'm going to explain a couple of things. So we look at Quantum Algo, and for Quantum Algo, we look at the obligations provided for under the agreement. As you can see here, there's two things that I want to highlight. Clause 2.3.2, it says they're supposed to ensure and maintain an error rate of below 0.1% at all times. It's a non-negotiable from where we came from. The other thing was to ensure that, and this is one of the contentious issues here today, clause 2.3.6, to ensure the algorithmic capacity. So as Titan, we have a risk management software protocol. And the idea was to ensure that whatever it is we have, that risk management system protocol should be compatible with the algorithms that Quantum Algo has or is supposed to present and share with us accordingly. So we are here to the whole issue came up in email correspondence. So we flagged the issue of the non-compliance, non-compatibility issue. And we did have a discussion about it. So we did raise it before the actual event happened, which I'm going to explain briefly. So when that happened, they said they were going to give us a new phase. So they said 2 weeks, I think roughly 2 weeks before the incident took place, we were supposed to have an amended version, right? And you see, the problem here is we never got that. And the reason this exists is kill switch. Now, a kill switch, as outlined here, I know you guys are lawyers and it might be a bit difficult to understand what that is. Besides the compatibility clause which I've espoused here, the kill switch was supposed to halt any trading in instances of irregularities and anomalies, which happens in the market because the market is very volatile. So you can't have instances where things go up and things go down and things don't make sense. And this kill switch, this safety measure that we had directly stated in our contractual agreement to be included, was not included in the algorithmic setting that Quantum Algo was supposed to give us. Now, you can already see from there that that's one of the errors. You see, there's a lack of proper supplies for what was contractually provided for. Now, what this led to is there was executions over 15,000 executions, erroneous executions were released within a period of three hours. And that means that, and I know Mr. John is going to talk about this, there's some losses we both encountered. So there's losses that Orion encountered, and there's also issues on our end. The reason this was an issue for us is because if they had put in this material compatibility issues and they had dealt with the kill switch requirements, we had flagged it within the first hour, right? And therefore would have some way stopped the losses that were being incurred by Orion and also us, because it exposed us to so many things, right? So their lack of adherence to this compatibility clause and this safety requirement, this safety net, the kill switch requirement, put us in a very precarious position. Now, you see what happens is when we raise these concerns, and give them an opportunity to remedy them, and they didn't remedy them, and we encountered this, we raised this issue with Quantum Algo, and we said that it's a problem from where we come from. We are having very interesting time understanding how we would have been able to manage that, because it's a very manageable thing. And one of the things they mentioned is that we were at fault, which was very, very surprising, because they talk about market data. And the whole issue was, if this whole institutional things were done, algorithmic bias and all these things that were supposed to be catered, the market volatility and these things that were supposed to be dealt with were dealt with at the specific time, then those transitions of those data and market information would have not gone the way they would have gone. So ideally, they're blaming us for something that is fundamentally their fault, right? Because the misinterpretation is something that happens because the market is generally volatile, but because that interpretation came as a result of the 15,000 erroneous entries, right? These entries actually led to this flash crash of a lot of illiquid securities. So you can imagine, as a brokerage institution, what that means for us, what that means for our other partners who are involved in this specific loop. So one of the things that is really concerning, and I think I want to hear what you have to say about this, is the issue of regulatory bodies. Now, regulatory bodies are on our necks. As you know, markets are very sensitive. Markets are financial places, and everybody is doing things there. It's the thing right now. So if anything goes wrong, that regulation is very high and very strict. And so we are being accused, or there's hints and instances around the air and tension in the air, that whatever happened on this sad day was a market manipulation. And you see, it's a contract among three people. So you can clearly see where they're going, that even though it is a fault of one company who created an algorithm that didn't meet the contractual standards, then all of us are automatically dragged into the mud, because the whole basis the financial institutions such as FCA rather are raising is that this issue of market manipulation violates market rules. Now, from where we stand, we're very compliant. We had given our contractual expectations, and none of this were adhered to. So, and I know Mr. John is going to also talk about this, that we went to collectively, we sought to get arbitration. So we were supposed to do that under SIAC, that is Singapore International Arbitration Center, because we really felt strongly that the things that were being done by Quantum Algo constituted a breach, because we had clear provisions in the contract that says you need to have the kill switch, you need to do this, you need to do that, and they didn't do that, and it cost both of us. And I know that Orion also suffered as much as Titan suffered in this instance. So besides that, there's negligence, because one of the claims they were raising was the issue of it was uncontrollable because of geopolitics. And one of the things we sat down with Orion and discussed is, how is this something that is uncontrollable? We gave you an appropriate way to regulate. If you had installed the kill switch requirement, you would have mitigated anything. 1 hour, we figured it out as a company in 1 hour. This program ran erroneous things for 15,000 entries in a span of 3 hours, and it led to so many losses. So if we're able to have that compatibility, then ideally would have prevented anything. So negligence, that's another thing. And the whole idea of the whole discussion of, they said this algorithm is amazing, it's going to do this and this and this, it's going to work like this and this and this. That's not what we got. So it was, in a layman way of speaking, what you ordered for and what the delivery man gives you. So we have two stark, distinct things. Contractually, we have already provided what it is we want. And then we see that this is not what we want, and we raised questions, and they kept promising us through email correspondence, which I will also share if you're willing to have those as well as something to help you figure this out, that we did make notice, and this 2 weeks as well. So when you're coming to this, it's something that's very important, but we're looking for money because we are at a very interesting place, especially in regards to the brokerage licenses, because we are risking being called a non-compliant organization and company as per market standards, puts us at a risk of losing our license. So are we going to lose our license? That's something I'm keen to know. And this system failures, can we be attributed to these system failures, in as much as we were also, I will say, a victim of circumstances in regards to the same? Yeah, I'm yet to hear. I really want to hear what you have to say about that. Maybe Mr. John can tell us his perspective on the same.
Thank you, Miss Simran, for mentioning the common facts that we both share with each other. Councils, I want to share something that, as Miss Simran mentioned, that there were 15,000 erroneous trades within 3 hour window, and that those 15,000 erroneous trades have cost us $200 million, and that's a very big amount for us, being a capital company. What happened was they initiated the algorithm initiated trades at an incorrect price points on the LSE and SGX, that is London Stock Exchange and Singapore Stock Exchange, which triggered a flash crash in illiquidated securities, which Ms. Simran also mentioned. Uh, these cascading losses were further exacerbated because Quantum Algo, the third party that is there in this contract, failed to activate the kill switch, which was embedded in the algorithm, despite repeated anomalies in trade execution patterns. And what were kill switch for? To halt the trades at the moment that where there is a regularity. And irregularity was, and the scope of irregularity was very low, like 0.1%. If it had gone 0.2, it should have been halted, but we have suffered this much loss. And then the Titan Securities Limited comes. The kill switch was the algorithm was provided to them also. In the first hour itself, they detected that there is irregularity, there are errors that are occurring in the trade, but they tried to activate the kill switch in within the first hour, but it wasn't. They weren't able to activate because the quantum algo didn't provide them the patch update for the software, which they contractually promised us in an $800 deal. So the thing is, they haven't done this, and they are claiming that there are latency issues with the system and software of the Titans. There can't be so much latency. They are just claiming, they are just blabbering some excuses with us right now. And next, they are claiming force majeure in the market. Like they are saying the market going up down is a force majeure. It's a market, it goes up and down. And regarding the Ms. Simran has also mentioned that the regulatory authorities of three jurisdictions are at throat, the Singapore, the UK, and the USA. So we want the Titan company wants some compensation regarding their reputational loss, and we also want some compensation regarding reputational loss, and for those $200 million also. So please, Council, can you lead us for that?
Yes, so thank you both for mentioning these things. It is understandable that both of you have respective interests and that it is a difficult situation that both of you have been put into. So ideally, coming forward, it seems that both of you do have some common ground in terms of reputational damage and recovering for financial loss. So keeping that in mind, we will try and direct our advice to something that can help you with these matters. Ideally, I would like to ask, so based what I do here is that both Mr. John and Ms. Simran have told us that basically it is you've fulfilled your contractual obligations. However, it is it is the other company that is basically not being able to or failed to do their contractual obligations, and thus it has caused mismatch between what they believe to be true and what is actually true. So keeping that in mind, do you have any documentation or evidence that shows that reflects quantum algorithm executing these erroneous trades? Is there anything that can help substantiate that claim so it can help us understand?
Yes, we do have. Okay. From Titan, we do have a document. We have a report that's ready. The only issue is that it's very heavy in nature because it goes into the intricacies in the times. So it does a time loop after every few seconds in the market. So I will share that in the email correspondence if I'm allowed to, for reference sake. So you can be able to see how that irregularity went about.
That'll be appreciated. Thank you, Ms. Simran.
And Council, we also have all the documents regarding the contract and also regarding the Titan's communication to the quantum algo for providing them with the patch updates that they didn't. We also have for soft copy, we also have hard copies that, of the notices that we sent.
That'd be great. If we can also request you to send those over, we'd be able to see them properly and go through them. But if that could be sent over, that would be much appreciated. Thank you, Mr. John.
As stated by my co-counsel, we do sympathize with what a terrible situation you have found yourself in to both Orion and Titan. And we also appreciate the documentary preparedness that it seems both of you have embraced. It will be extremely helpful down the line, no matter which way your claim does go. And we are taking notes of what is said, but also as referenced in my NDA, these notes will be disposed of immediately after the meeting, but it is to allow us to cater to your interests to the best of our capability. And I believe that in my notes I can see that I believe that Mr. John stated that that Orion experienced a $200 million loss. And I'd like to ask, can you walk us through how the $200 million loss was calculated in this specific instance?
Council, the loss was calculated by per per transaction, and there was 15,000 trade transactions. So per amount has been calculated to the $200 million. Council, you are on mute.
Thank you so much. That is well noted. At the time of the incident, were you operating strictly within the agreed leverage caps that were placed, or was this an automated response or a response to market movements?
Council, whatever limit
This is,
that was
sorry, just go
recommended
ahead.
to us by Quantum, uh, all the limits were being followed, and there was nothing that we have overlapped or something, which Quantum always claiming against us. So there isn't any non-compliance or negligence in our side at all.
That is, sorry, that is well noted. Thank you. Co-counsel, would you like to follow that line of questioning?
Yes, actually, Mr. John, I would just like to clarify. In the papers that we received, it did say that both you and Titan were looking for $250 million in damages. So were you speaking as 200 million as for your share and the remaining 50 million for Titan? How would that be split or
First, we are aiming to just get this from the quantum, first of all. Then we will see what is the fine that Titan had to pay because three of the regulatory authorities are on there. So we will talk about that within ourselves.
Okay, thank you. And just as a follow-up question to that, and this is for both clients as well, in terms of the current situation with the regulatory bodies, I am aware that you have incurred fines from them. Can you walk me through what the current situation is like? Have they served the fines? What is the process in going? Because I do know that these regulatory bodies, especially the financial conduct services, also do have specific procedures. So if you could just walk us through what the current standing is with them.
Okay, I think I can take that up. So far, as of now, we only have a preliminary finding from FCA. And as I mentioned earlier, the findings are market manipulation along the lines of you violated market rules and standards and such like things. So the issue here is they are citing relevant laws because of compliance. And now the issue here is when these issues are flagged and there's a preliminary finding that is done, and that clearly outlines that that is just the beginning of what they're going to do. And that's what I was saying. We run the risk of our licenses being revoked as they are or being suspended as they are currently undergoing the search to understand. So who caused this market thing? Was it really a market manipulation? Who was indeed responsible for this? So those are the kind of things. So once they have um identified an issue and identified and made a preliminary finding, they will now stop people from undertaking certain actions as a means of hopefully curbing the losses within the market. There are sanctions that we are likely to face. We are being threatened with the sanctions in place. So we have things hanging around. We have wind that these are things that are coming. So we are anticipating the hit. And that's exactly why Mr. John is saying once that $250 million sum comes, we will be able to know how we're able to divide it because there's a lot of issues that are coming along and we are the ones at a very big risk because when you are a brokerage, you are in the interim. And I think those things have directly been faced as well. And also the equity that is being raised by Orion, some of that 800 million sum substantially came from them. And so there's also losses that have been cut because cumulatively, this was something that we were doing together. So the preliminary finding, suspension or discontinuing of market interactions, which is a loss in our business if you think about it, the agreement that we have, and so on and so forth. Yeah.
Council, can I add something?
Yes, please.
Council, as you know that the three of the regulating authorities are on us. So, is there any principle of you in your legal language say a principle of natural justice that we can have so that at least we get some time from the actions of regulatory authorities?
Would my co-counsel like to take this question? Or?
Yes, I gladly answer your question, Mr. John. Uh, in regards to the parallel regulatory investigations that are currently ongoing into Orion and Titan, there is a legal separability of regulatory and civil liability. Therefore, in the arbitration that I believe you both have already instituted under the Singapore International Arbitration Center tribunals, these tribunals can consider regulatory findings that may be found, but they are considered in a persuasive manner. They can take them into account, but they do not determine the outcome of any decision that may be made. I hope I have answered your question in a satisfactory manner, or would you like me to go into more detail on that?
I would just like to, can we directly negotiate with the regulatory authorities that at least give us some time, at least give us some time to justify us what has happened? Is there any way to do that, or we are?
In fact, yes, there is a way. To make sure that I have understood you correctly, you have said that you would like a period of time to negotiate with I believe, with Quantum Algo on this matter.
No, no, not negotiate with Quantum Alco. We just want some time away from the actions of regulatory authorities. That please give us at least some time for what has happened. Then please halt your investigation so that we can focus more on the thing regarding what has happened in the market regarding three of us.
And I
So we
think in addition to
can,
what sorry, and I think
it's
in
okay,
addition
go
to what
ahead.
Mr. John is asking, maybe we can think about the negotiation. Can we think about how maybe the stopping of the revocation or suspension of our licenses can work? So I think what he's trying to say is there anything we can do before these things that they're threatening to do take force? Can we explain? Is there what is it called? A means we can sit down and ensure that before this effects hit us, we have justified our way, or we have ensured that we have dealt with these things internally, or we are dealing with these things internally, so we don't have a lot of losses on our ends. I think that's what Mr. John is asking.
Yes, Ms. Simran, that's exactly what I am trying to convey.
I would just like to give some context to the situation in terms of this. As my co-counsel has rightly said, in terms of the negotiation, the process in terms of these bodies, especially the regulatory bodies, their process works in such a way where ideally what they will do is they will evaluate based on what has happened in the market. So what they see is not the actions behind it. What they see is what has happened within the market. So ideally, if you look, actually, I will refer, and this is something you can see as well in your own time, but the Financial Services and Markets Act 2000, I don't want to put too much legalese into the conversation, but it does regulate certain things in terms of showing that if there is market abuse, what the regulatory body will look at that and what has happened in the market. So what they see at the moment is the artificial price changes in the market, and that is what they see. So in terms of interim relief, what I would suggest and what we will eventually get to is that knowing that you have fulfilled your contractual obligations, the point is to show that in to get back reputational damage, the fact that this has existed, you want to show that not only have you done your contractual obligations and fulfilled them, but you want to show that you mitigated any type of risks that could have occurred, so that if you know that the algorithms were faulty, you didn't perform knowing the algorithms were faulty. It was not something that you were aware of, and thus you were able to, the losses that occurred were not because of you. But this is something that when eventually you work out, I think within the negotiation, you'll be able to refer back to the regulatory bodies, because their approach is something that they're seeing what is happening or happened in the market versus maybe perhaps your actions behind it. So if you can work out, perhaps, as you stated, you're already doing, you were engaging with quantum algo through arbitration means. So working out possibly something like this would be able to show that you are in the clear from these types of situations. You did not falter in implementing any internal controls to detect or prevent market abuse. So if you show these initiatives and these actions, it would also put you in a good position with the regulatory bodies, and to some extent even be able to get some reputational status back as well for further reference.
And counsel, can a apology declaration from the quantum algo help us in this matter? If we would be able to persuade them or pressure on them that to send an apology. Can an apology from the quantum algo help our reputation to be restored in the market?
I'll just ask a quick question, Mr. John. So if you were going to negotiation, and if you were to get an arbitral award from that versus an apology from them, which one would you prefer in terms of an apology versus an arbitral award, just so we can get some context into what would you provide more emphasis on?
No, arbitral award, we are mainly going for arbitral award for the composition that we need. Both of the companies, Orion and Titan. The apology that we can get from quantum, I think it can help us regaining the reputation that we have lost in this mishappening and in front of the regulatory authorities? That's what I'm asking.
So would my co-counsel like to answer?
Yes, I can shed some light on this matter. I do believe that Quantum Algo might not be in a position where they are willing to issue an apology. And I believe this is evidenced by them seeking to establish a counterclaim, trying to state that there is negligence on the part of Orion and Titan. So I therefore believe that maybe seeking an apology might not be as might not yield the results that we expect as compared to arbitration and SIAC, which I believe you have already introduced. But I would like to maybe offer a suggestion, if it's okay with Mr. John.
Yes, it's absolutely fine.
So just for purposes of context, SIAC arbitration is a private binding dispute resolution process that is administered by the Singapore International Arbitration Center, and it's governed by procedural rules within SIAC and Singaporean law. And I believe there is no seat of arbitration stated in the initial filings, is there?
Yeah, yes.
Okay. Therefore, the seat of will actually be Singapore. And prior to mediation, or sorry, prior to arbitration, you can seek pre-arbitral mediation under SIAC. It is a form, think of it as a form of mediation within arbitration. It's SIAC strongly does encourage the amicable settlement before or during mediation, if you can, because it helps parties in initiating arbitration if they are unable to come to an agreement. And the agreement that is come to in this initial phase, in the pre-arbitral mediation, is normally referred to as a consent award if parties are able to agree before reaching the actual arbitration phase. And similar to the arbitral award, the consent, similar to the arbitral award, the consent award is also similarly legally binding to both parties as an arbitral award would be. The arbitrator or arbitrators in question would, the arbitrator or arbitrators in question would be able to finalize it in a similar manner to an arbitral award. If the settlement is agreed by the parties, it is issued again as a binding arbitral award. And it is also key in enforcement because 170 countries, including the countries relevant here, by Singapore and even the UK and the US, they have co-signed to the International Arbitration Act, and they can therefore be held. It can be enforced in those different jurisdictions. Mr. John, I hope I have not lost you in a bit of the legalese.
Yes, yes.
I have
Do
a
you have any?
question, Council. Oh,
Go ahead. Go ahead, Ms.
no, okay.
Simran.
Great. So we've mentioned arbitration, and I'm curious to see. We've talked about having an interim relief as Council has otherwise mentioned, but now I'm thinking, how does arbitration affect the investigations going on? So they can happen in tandem? Is that a possibility? How does that work? We are yet to go for arbitration. I think that's why we are here. We want to get what medical doctors say, second opinion. Is there maybe another avenue we can explore in the interim, particularly to see how we can make these things better? I think one of the things that, and I hear Mr. John and I are on the same page on this, is in as much as we want money, we want our reputation fixed. If there's anything we need, is our reputation fixed. So can you please explain those two issues? And then if any other question comes up, I can be able to ask. Yeah. Thank you.
So just to confirm, you have asked whether the first question was whether the regulatory investigations can carry on in tandem with the arbitration proceedings going on.
Yes, and if there can be an overlap and anything of the sort. Yes.
Was that the overlap was the second question, or was there another?
No. The second question was, is there any other means that can be used in the interim? So we are facing investigations, we are awaiting arbitration. So is there anything that can be done in the middle? How would you advise us to go about it? Is it safe to go about it, or do we just wait for arbitration and see where it goes?
Okay. I will tackle the first question in regards to whether the regulatory investigations can go on in tandem with the current initiated arbitral proceedings, and I believe my co-counsel can tackle the second question, if that's okay. So, with the first issue, whether the regulatory investigations can go on with the arbitral proceedings that are currently already instituted, yes, they can go on. As previously stated, they can go on. However, there is a big difference between regulatory authority and civil liability. It would not have it. The regulatory findings may have a persuasive effect on the arbitral proceedings. However, they do not have a determinative effect in that they cannot be used to wholly determine the outcome of the arbitration. And similarly, what is disclosed in the arbitration, because arbitration is a confidential process, what is disclosed in the arbitration cannot be disclosed or divulged to help or aid in the ongoing regulatory investigations. There are two distinct processes. The risk of the information being divulged is completely at a minimum. Therefore, as you have said, companies, Orion and Titan, are concerned with, I believe, the reputational damage that they may experience. And I believe arbitration, therefore, would be a recommended. I believe the pre-arbitral mediation, and then if it does fail, arbitration would be the recommended avenue due to the confidential nature of both processes. I hope I have answered your question in a satisfactory manner.
Yes, you have. Thank you, Counsel.
You're extremely welcome. And at this juncture, I'll invite my co-counsel to tackle your second question.
Yes, could you, Ms. Simran, just provide some extra clarification to your second question, just so I can tackle it correctly, please?
Okay. So my second question, hold on. She actually answered the second question. You did. But I have another question, lest we are worried about lack of questions, is the issue of we're in different countries. So let's start with Orion. Orion is in Dubai, I am in Singapore, and Quantum Alpha, which we're discussing today, is in India. And one thing I've seen in business as a representative, I've had an awesome opportunity to work under this company, is there's something called an award that is given after arbitration, which I think you seem to advocate for, but you'll tell us more about it, hopefully. So we're in different places. So when we have that award made, how do we make it effective? I don't know, maybe there's a legal term for it in a different place, because where we are is Singapore and we want to use SIAC, which is also based in Singapore. So how do we merge those two? Is that going to be a problem? Is that something we should be concerned about with the process? Or there's a way it works around anyway, despite the different countries and everything?
Could I just ask a follow-up question to that? In the contract, Mr. John mentioned that there was an arbitration clause.
Yes, there was an arbitration clause that we will do anything with the SIAC itself.
Okay, and was there a specific reason why SIAC was chosen?
Because broker is in the Singapore, the Titans are in the Singapore, that's why.
Okay.
So the middle ground we took as Singapore itself.
Okay, thank you.
And counsel, can I ask, we are talking all this, what would be the first major step that we have to take from now, from today itself? What would be the first major step that we have to proceed towards?
I think that's a good question, Mr. John, and thank you for that. Actually, just my counsel and I were planning to actually move towards solutions at this point, as we believe that we've gotten significant information and understanding of where the issues lie and how we can best probably advise you. So if you want, then I can start based on, I think if that's all right. So I would just like to get the force majeure defense out of the way from quantum. quantum algo. So I think, as both of you have mentioned, force majeure does have to be an unforeseeable event. It has to be something outside of the party's control where they cannot fulfill their obligations. However, usually a volatile, and as both of you have mentioned, a volatile market conditions are not really, or they don't really constitute a force majeure event. It's considered a known risk in trading, especially high frequency trading. So parties in the contract, which I'm sure all three companies must have been able to understand that in high frequency trading, possible risks of market instability are likely to occur. So you can rest assured that the force majeure claim that they're trying to bring against you is not likely to stand. And secondly, in terms of the contractual obligations, thank you for letting us know that you do have a record of all the types of reports and documentation to show that you have fulfilled your contractual obligations. And it has shown that it is actually quantum algorithms that have failed to provide support to your abilities to work within the tripartite deal. And if that works, then technically it does occur as a breach of contract. So just to provide some stability in terms of what could happen in arbitration, you would like to go in knowing ideally what you can negotiate for, what you believe you are entitled to, and how this can work in tandem, as you mentioned, with the regulatory bodies and their investigations. So if there is, just from my side, if it's clear that you do have evidence that quantum algos have breached their agreements within the contract, then ideally this is your main defense in terms of the fact that you've done everything that was mentioned in the contract. And it would also show that due to their inability to fulfill their obligations, you did not falter in ensuring that you implemented internal controls, you tried to prevent market abuse just by the fact that you had already done your contractual obligations. And this would enable you technically to prove the cause for the artificial price movements. It would show that it had nothing to do on your part. So just rest assured that we would want you to leave this client interview feeling assured that even going into arbitration, whether there's a consent order or arbitral award, you will be able to have a good standing. And from that, I'll pass it on to co-counsel given the time constraints.
I believe that co-counsel has covered all the fundamental bases in regards to the claims for breach of contract, which we have affirmed that yes, the contract was breached as Orion and Titan did fulfill their contractual obligations, which does in fact defeat the force majeure defense and makes it clear that this was not a case of contributory negligence, as I assume Quantum Algo will try argue. And I believe counsel and I are in concurrence in the fact that the best way forward is to, I believe that you both hinted at previously seeking legal advice, and I believe that you were offered amazing legal advice. However, we would like to add a small caveat that we do believe that it is best to seek a pre-arbitral mediation prior to the actual arbitration proceedings, as it will enable you to not leave the outcome in the hands of a third party. It will enable you to have more control over what outcome you could have. It will enable you to put your interests first as opposed to getting a final verdict from an arbitrator, and it is binding. And as I believe Ms. Imran had hinted at, that Ms. Imran had hinted that she was concerned about the existence of multiple jurisdictions, and I would like to again reiterate that all these countries that I involved, Dubai, Singapore, the US, the UK, India, they're all signatories to the SIAC, and therefore they are held liable by any arbitral awards, despite it being determined in a different jurisdiction or in a different locality. And with that, I will hand it back to my co-counsel to close. And I'd like to thank you all for the amazing session we have had.
Counsel, can you elaborate? Can you tell us the fee of this session that we have to pay?
Oh,
I am also
okay.
mentioning both of our email ID in the chat so that you can share us the relevant documents.
Thank you very much. We will share all the documents in the same email chain we have been having so far. And on the matter of fees, we as a firm, as we state, we prioritize in commercial law matters. Therefore, this first counseling session will be free of charge because we do believe in bolstering entrepreneurs in our society today. But future fees would be subject to maybe the capacity you'd want us to play in an advisory capacity, or if it requires for the mediation session, or for even for the arbitration session in itself, the fees would be subject to which role we do play, but it's nothing out of the average market values that are currently there.
Okay, Counsel.
But we can share the fee schedule and the retainer schedule. And if it's right up your alley, we are here and we are very excited to assist you in this matter. We are here to help.
Thank you so much,
And I'd
Counsel.
like, you're extremely welcome. I'd like to close there. Thank you very much for an amazing session.
Thank you.
Thank you, participants. We'll now proceed to the post-consultation discussion for the next 10 minutes. And I will now kindly ask the clients to exit the Zoom room. Thank you.
Lovely. So how do you believe that went? I think it went quite well in being able to understand their perspective of the situation, being able to understand. It's good to know that they do have relevant documentation, as that will really help them when they do go through arbitration. And thankfully, you mentioned the different routes and the jurisdictions as well. So this will provide them assurance should they go forward and understanding how to handle the situation with the ongoing investigation as well.
I agree. I believe it was an open and constructive discussion. I believe in the beginning, they are both brought here by the fact that they care deeply, they care immensely about the well-being of the individuals and respective companies, but they did have maybe some sort of differing interests, but we were able to harmoniously unite that into one couple. And I believe you tackled the matters to do with the basis of the law well. You dealt with negligence, you dealt with the claims of the breach of contract, and I believe you covered that really well, including the force majeure defense, which I completely agree does not allow for force majeure. Plus, in Singapore law, it is required that an express force majeure clause be there.
Definitely. No, thank you for that. At one point, I hope that I didn't with Mr. John when I proposed whether he preferred an arbitral award or an apology. What I was hoping to actually gain from that was just an understanding of the situation, how they felt in terms of what they would really like. So hopefully that, and luckily, Mr. John answered well, so he was able to, guide the discussion into understanding what would best work for them. And I hope that they do leave with the proper assurance that they can take good steps and that they're in a good standing towards defending themselves against quantum algo.
Do agree. And I liked how you posed that question because it feels clear that you were trying to understand their priorities going forward, to understand that at the end of the day, this might end up being a give-take situation. And if they do decide to pursue this matter in future, and if they do decide to retain us, I believe they will be pursuing this matter in future. But if they do decide to retain us, I believe we have strong legal standing from which we can operate, whichever means they do opt for, whether it is the pre-arbitral mediation with arbitration as maybe the last port of call or straight to arbitration. I believe that if they do decide to retain us or even any other lawyer, they do have a strong legal standing. They do have a strong legal defense as they have made it clear that they did fulfill all their contractual obligations. And I believe they did so in a question that you had posed.
Mm-hmm.
Yeah, and I believe that was extremely clear. It came out abundantly clear, and I believe it was well tackled.
Thank you. I think it was a good job as well. I'm glad, as I mentioned before, that you brought up the various, were able to answer Ms. Simmon's questions as well. I think that provided some clarity as to what to do when the regulatory bodies were undergoing these investigations, and hopefully that's kind of given them that understanding and support. But well done on that point.
I do agree, and you can tell they are really concerned about the sanctions they may receive from these regulatory bodies. And I believe you did a good job of coming in and making it clear that they can seek interim relief in the meanwhile. And abundantly clear from both ends that they were worried about whether even the regulatory investigations could have an effect on their arbitration proceedings or vice versa. And you could tell that they had sought previous legal counsel or previous legal advisory opinions, and they demonstrated at least a bit of knowledge of what was going on or what processes we were referring to.
Definitely. I agree with you completely. And just with everything, I think it was an overall good meeting. And if we were to have any further discussions, I think we would have a good position in which to understand what their next steps are. And if they do continue with arbitration, which I do believe that they will, then it would be good for us to see what the whatever reward comes out of that, and how we can move forward with that should they decide to stay with us or come back for further.
I do agree, and I believe that the fact that they are brought together by their sincere concerns for their respective companies is a really big driving force behind their decisions, behind their logic, behind the options they are opting to go for. And I do believe that arbitration may be their best way forward, and they may yield at the results that they both seek, and to provide an equilibrium between both their interests. As they've made it clear, they are not here to represent their own interests. They are also here to represent each other's interests, as they are united front against quantum algo in this specific scenario.
Most definitely. And the fact that they came with the understanding that it was not necessarily their wrongs in terms of they were not able to fulfill their obligations, but rather whatever did happen as a result of their systems. For example, when Miss Simran was saying about the kill switch, it was not necessarily their fault, or especially with the specific transactions or the security management system of Mr. John and Orion. It just goes to show that it was not necessarily the issue was with their systems, but it was the fault of quantum algo that was not able to allow them to fulfill their obligations in a way that was intended when this agreement was signed. So hopefully this can be something that the regulation authority can see, and they can hopefully recover some reputation from that loss, and hopefully including the 200 million, as it was quite a big loss that they faced. So ideally it would be hopeful that they can recover that as well.
Similarly, I do agree with you that Quantum Algo did owe a professional duty of care to both Orion and Titan. And also, I do hope that if they do end up in arbitration proceedings after hopefully trying the pre-arbitral mediation or hopefully opting for it, I sincerely do hope that they pick an arbitrator based on expertise, and they're able to pick an arbitrator or arbitrators who are well versed, who have expertise in this sector of high frequency trading. As I believe Miss Imran had mentioned earlier, I don't know if you caught it in the beginning. She did mention earlier that she does understand that maybe we as lawyers might not have the business acumen or the tech mindset to understand that or to understand or be well versed in some of the issues they were raising. And I similarly hope we were able to break down the legal knowledge for them into digestible pieces. And I do hope that they do find an arbitrator or arbitrators who are well versed or who have expertise in the topic. And I believe that we will also still communicate this to them in future, hopefully in future sessions.
I agree. I think having a specific knowledge of the industry, especially high frequency trading, you need to have a certain sense of management, monitoring, and control over the algorithms that are involved. So being able to have an arbitrator who can understand this would be able to understand where both Titan and Orion come from, and be able to give them hopefully something that matches that level of understanding, something that perhaps we were not able to see, but something that can understand how the markets work, and to show perhaps the regulatory bodies it was not a sense of oversight, but it was strictly a sense of a failure of contractual obligations. And if that can come through, then that would be great for both of them.
Concur, because to even see through the defense of force majeure, because they're claiming that market volatility and geopolitical events is what led to their claim of force majeure. But if we're being honest and if we're being honest and frank about the law does recognize that market volatility and geopolitical events are foreseeable risks in high frequency trading. So if they do get an arbitrator or arbitrators who can be able to be nuanced with the law and also with sectors, or rather the entire sector of high frequency trading, I believe it will work well to their benefit and ensure that they do get a binding arbitral award that does manage to balance both their interests.
Definitely. I completely agree. And I think on that note, that's all I have to say, co-counsel, in terms of this interview. But I'm very happy with how it went and hope that they have a good resolution in terms of that.
Also hope that they do happen to find a manageable and amicable solution. And I must say it was a pleasure working with you. And I do hope to be working with you again. It was indeed an amazing experience.
Same here, likewise.
Thank you, participants. We will now open the floor to our esteemed judges for any questions they might have, if any.
Yes, Kritika, you please first go, if you have any. They
Uh,
are so brilliant, actually.
yes, absolutely, absolutely.